Very good evening and a warm welcome to our episode on Law and Order. And today we are about to discuss the concept of access to justice and what can we do to make justice more accessible to the common citizen. And today we are happy to welcome at our studio at Sri Lanka Rupavahini Corporation, Mr. Aritha Wickramasinghe, the Equality Director of I Pro Bono.
Thank you very much for having me again.
Definitely, sir. And first and foremost, I would like to blatantly put a question to you. Why is access to justice considered so difficult and costly globally and particularly in Sri Lanka?
I mean, access to justice, Shahara, is difficult because, as you said, it's expensive. You know, it's expensive and it's complex. For most people who haven't got a law degree, to understand a simple piece of legislation, to understand the complex procedures which our institutions have put in order to access justice can be quite difficult to navigate. And because it's so difficult to navigate, it becomes also more expensive for someone to be able to access and navigate through that. And that means you actually end up denying or limiting access to justice to many people who should be entitled to it.
And also, when we talk about access to justice and how people are denied from it, what remedy do they have? If a person is aggrieved by a particular action by the state or an action by a private individual, what remedy would he or she have instead of facing a huge financial burden on himself?
I mean, access to justice doesn't necessarily have to come at the sort of litigation stage or remedy in that sense. Access to justice is also something as simple as having a accessible and a friendly police station that you can go to, you can file a complaint, you can be treated with respect and with dignity, and that your complaint will be taken forward and you'll be kept updated on your complaint. So that is, I think, your first step to an access to justice. And then you have the more litigious side of access to justice, where you can go to a court to argue or to complain that your rights has been violated or anything you've been entitled to has been taken away from you. So because of the complexities and the expenses around it, of course, services such as the Legal Aid Commission, you have many pro bono services which are out there. Those are services which, individuals or organizations can make use of in order to access justice where they are finding it either too complex or too expensive. So such avenues are available. But again, because resources are limited, the ability of these organizations or these pro bono lawyers or the Legal Aid Commission to go that step further becomes more difficult and more restrictive. And that means, again, only a few people will have access to justice at the end of the day.
You spoke of an interesting concept, pro bono. I doubt whether the citizens of Sri Lanka are aware of this word pro bono. What is meant by pro bono?
Well, it's a Latin legal term. It means for free. So when we say lawyers are doing pro bono work, it is for lawyers who are doing work for free. And that is something which I pro bono, for example, the organization which I'm representing here, which we were set up for. And our story is actually very much related to access to justice. So we started this in the UK. I'm an English lawyer about 10 years ago. This was soon after the financial crisis and the many cuts to legal aid which happened during the government in the UK at that time, because of course government revenues were declining and there was austerity. So when there were all these cuts to legal aid, we realized that, okay, a lot of people now who had some form of access to justice because of legal aid no longer had that access to justice because access was just too expensive now. And then we had all these lawyers like us who were working for big corporate law firms. And, you're a lawyer, Shahara. When many of us decided to become lawyers, we weren't really we weren't imagining reading a 300-page loan agreement, right? That wasn't our desire to pursue a career in law. It's because we believe in justice. We believe that everyone has rights, and we want to be part of that journey to ensure that justice is served. And so we thought, okay, look, there are all these lawyers working at these big corporate law firms doing things which they never wanted to do in the first place. And now we have all these thousands of people who can no longer afford lawyers. So how about we bridge this gap between lawyers who want to do pro bono work but don't know how to do this work, and they don't have access to the people who need this help, and let's connect them with the people who want access to the lawyers. So that was what iProbono's intention and purpose was. So we bridged this gap. And it's kudos to the lawyers. We often get a bad reputation. Most people think we're just out there to get them for every penny possible. We have today about 80,000 lawyers on our platform in about 39 countries, delivering millions of dollars worth of free legal aid and assistance to people who are denied justice.
And you spoke about pro bono work in general. What is the culture in Sri Lanka when it comes to pro bono work?
To be honest, there is a strong pro bono culture in Sri Lanka. When we were in the process of setting up iProbono's work here and engaging with lawyers to join our platform, we realized that a lot of lawyers were already doing pro bono. But the problem with the pro bono system here is that it's not structured well, and the work is quite ad hoc. And most of the time what you see is lawyers don't get enough support either from their senior partners, from the law firms, or even from the bar association in order to do pro bono work. It's almost as if pro bono work is seen as something, it's nice to do, but it's not priority. And therefore, it means there's not enough attention, emphasis given on the work which needs to be done. So I think a restructuring of how pro bono work is actually done, making it more organized, giving more recognition to the work of lawyers who do this pro bono work, would actually help far advance access to justice overall in Sri Lanka, and also in a way take a lot of the burden out of the state, which is having to fund a lot of the Legal Aid Commission, having to fund persons who are denied justice, who seek some claim against the state. If they're able to sort of outsource this through encouraging more private lawyers to take up pro bono work in a more structured manner, you can see this part of, you can see access to justice improving incredibly here.
And also, practically talking, if one of our viewers wants to get legal advice on a particular issue, or wants to see the possibility of filing action against another party, where should he or she go to? Are there any organizations who specialize in pro bono? Is it only the Legal Aid Commission? Or are there any individuals you could go to? Because pro bono is not in the common vocabulary of the Sri Lankan citizen.
No, there are plenty of organizations which are doing some fantastic work, but like I said, because of limited resources and funding, it means that their work can again only be limited. So if you look at it from a child rights perspective, I work with an organization called the Child Protection Force. They do fantastic, groundbreaking, precedent-setting work on the enforcement of the rights of children, especially children who are victims of sexual and physical violence. Then you have Women in Need, which also have in-house lawyers which do fantastic work on enforcing the rights of victims, mainly women victims of domestic violence. So those two are some, very incredible organizations which are doing very difficult work with the limited resources that they have. Then you have the LGBT rights groups. A lot of them do find it difficult to get lawyers to come on board, but generally organizations like iProbono, we facilitate in providing lawyers to assist LGBT rights organizations with any legal issues they face, especially amongst the community members that they work with. So you have a few organizations which are doing this work. There is, of course, the Legal Aid Commission, which has been there for a while, which do incredible work themselves. But But I don't think enough work is actually being done from a access to justice point of view when we look at strategic litigation issues, especially enforcing rights, trying to set new precedents, trying to shape, and this is something which is incredible in the pro bono sector, is that a lot of us are working in such difficult and contentious areas, and it gives us the opportunity to shape the legal landscape in these areas. And that's really rewarding, and that really makes you realize the purpose of why we took up these professions in the first place. We didn't take it up because we wanted to read a 100-page agreement, commercial agreement. We have some kind of passion for the work we do, and for all lawyers. And I think the scope which doing this kind of pro bono work gives us lawyers is really worthwhile.
And also you spoke about how pro bono work is happening in Sri Lanka, although it's not discussed maybe on mainstream media or discussed among the general public. What incentive does a lawyer in Sri Lanka have to engage in pro bono work, or what guidance does the organizations which supervise the legal profession give to lawyers in engaging pro bono work? Or do you think there should be better intervention from governmental bodies and other organizations who impact the legal profession?
I mean, when we were setting up iProBono here, we spoke to and reached out to a number of law firms to understand what kind of pro bono programs they have, how do they incentivize their lawyers to do pro bono, do they place any value on it. Unfortunately, we didn't get any positive responses. So with that, it was very clear that even though most law firms do pro bono and most lawyers do pro bono, there is no incentive to do it. It's not recognized or valued. Like in the UK, for example, in the law firm I was at, we all had to do a minimum of at least 50 hours a year of pro bono work. That was mandatory for us. And most law firms have now adopted that minimum requirement. Some actually have higher requirements. And we also have policies where the hours of pro bono work you do will be recognized as the hours of work you do for a paying client. So it's given equal weightage, whether you're doing for free or whether you're doing for money, because the skills you're learning from it and your legal development is going to be the same. Sometimes I find actually my legal development is much higher when I do pro bono work, because the work is more exciting than actually doing plain paid work. So having policies within a law firm to have minimum pro bono hour commitments, to ensure that the hours you commit is given equal weightage as a paid client, to give more training opportunities for persons who are doing pro bono work, and also for things like the Bar Association and even government. In the UK, as a practicing English solicitor, I have to renew my license to practice every year. And when I renew my license to practice every year, I have to inform the Law Society, what exactly have I done during this year, the work I've done, what kind of pro bono work I've done as well. And then the decision to renew my license is based on what I have done during the year. There is no such sort of licensing process here for lawyers, right? You sit for your bar exam, you pass it, and you could never touch a law book ever again or read a judgment ever again, but you are entitled to practice law until the day you die. You actually, in a way, it sort of damages the quality of the profession that way if you don't have a continuous monitoring system to ensure that the quality of the profession is maintained. So maybe if the Bar Association here can introduce some form of licensing procedure, which has to be annually renewed, and which will be dependent on the amount of the quality of work which has been done, minimum educational programs which lawyers have to attend to, and which they can also make the number of pro bono hours you've committed to. If you can put that into your policy, even if licensing is too difficult to come to, at least as a policy of the Bar Association, the lawyers must commit to a set number of pro bono hours a year, or law firms must commit to a certain number of pro bono hours a year. Then you can see a real rapid transformation in access to justice for the hundreds of thousands of Sri Lankans who are denied it.
And also, You spoke about what reforms that must be done in order to make pro bono work much more streamlined and much more to incentivize lawyers to engage in pro bono work. Do you think that the Legal Aid Commission and other organizations should be there should be some sort of central mechanism which deal with pro bono work as a whole, or is the current system fine?
I mean, I wouldn't say the current system is fine. I think definitely if the various pro bono organizations could be talking to each other more, then you could see where, for example, a matter which the Legal Aid Commission is unable to take on, if they can forward it to another lawyer who is competent in that field, then they've still done their job, right? They've given a pro bono, they've given access to justice to someone who's come to them. But that kind of conversation doesn't really happen. And that is somewhat what Pro Bono is trying to fulfill through our work, is to be this platform which gives access to justice, where we are able to connect the different lawyers who are participating or actively doing pro bono work. Unfortunately, our engagement with the Legal Aid Commission hasn't gone very far, but it'd be good to see more communication
and collaboration.
Exactly, between all these fantastic organizations in their silos doing really great work. If you can really bring some form of a platform for them to communicate and collaborate with each other, we can see an exponential growth in the work they're doing and in access to justice for people.
And also, my question to you would be, now we spoke about pro bono work and how that can facilitate access to justice. In your opinion, what else should the Sri Lankan government or the Sri Lankan legal system, what else can the Sri Lankan legal system do to make access to justice more closer to the people?
Well, I think we have to start off with actually people knowing about justice itself. We have to make our legal system, from the judiciary to the police, a more people-oriented and a more friendly and a less cumbersome system to weave ourselves through. When you have a case, when you look at the average cases in Sri Lanka, an average property case can take 20 years. The average rape case takes 13 years. So when you are delaying justice through, these aren't normal delays, these are unacceptable delays. When you delay justice, you deny justice, you deny access to justice. So those are very fundamentals in our legal system which we haven't corrected. Some things which we can do is we can really update our civil and criminal procedure codes. I find that they're quite outdated, and that their updates is also a cumbersome process to update them. If you look at the UK, for example, the procedure codes are established through a committee established by law, and this committee can continuously update the criminal and civil procedure code depending on how the market is changing, how the legal system is changing. So in the UK, they changed this into this new system in 1997. Since then, there's been nearly 100 updates to the criminal and civil procedure code with practice directions on how to navigate through this system. In Sri Lanka, we have a code from I don't know when. I know there was an update recently, but it dates back decades. The whole code, and it's a legislative process. So we have to make it more people-oriented. We have to address issues of delays to justice. Lawyers also need to take responsibility for delays to justice, and courts should also be more reluctant to actually should exercise more caution and reluctance when delays to justice are happening, especially when lawyers are requesting postponements. All these things make justice expensive, and then you deny people that justice. So I think if we can get the fundamental right, and then if we can address the communication and the language gap to people right, then we can also, aside from the pro bono work, improve access to justice for Sri Lankan citizens.
And finally, my final question to you is, do you think that there should be law reform when it comes to access to justice, and especially when it comes to pro bono work, in a sense, to make law much more closer to the people? Because today what we see in courtrooms is that although we have beautifully worded fundamental rights chapters, although we have beautifully worded laws, most of these instruments are utilized by the people who have the powerful organizations, corporate giants, and so on and so forth, and not really people who are aggrieved on a day-to-day basis. What legal reform would you propose?
You're spot on. Public consultation of lawmaking is minimal to nil in Sri Lanka. From something as simple as changing road names, right, which are constantly changing, to complex legislation, there is no form of public consultation. Politicians and certain people they reach out to get together and decide that they're going to do something. They may listen to some groups of men who have an opinion on it, and then they go and push a legislation in a parliament also filled with men. And there is, the public are most of the time unaware. This also leads to actually lots of rumors and false information about laws being disseminated quite easily because there's no public consultation process. That is something which we should which should actually be in part of our constitution, that all laws should follow some form of public consultation process. The closest we got to a public consultation process, which was a fairly good process, was the public consultations they've had for the proposed draft constitution. Of course, we're not going to see that constitution won't see the light of day, unfortunately. But actually, to give credit to the work done by the Public Representations Committee, they went to every single district of this country to seek submissions from the people for what they want for their constitution. Submissions came from all over the country. They had sittings in villages, in town halls to seek these submissions. We are on our third or fourth constitution, second Republican constitution. These constitutions govern, how the entire functioning of this state and what it means to be a citizen of this state. To think that the public has never been consulted, on what their supreme law should be is a travesty. It's a travesty of their sovereignty. It's a violation of the sovereignty of the people. And the Public Representations Committee went and did this incredible amount of work. And then we set up a constitutional assembly which took in all the submissions of what people said. We had committees set up which were going to draft laws based on what people wanted for to be their governing law. And when you really looked at what people wanted, they wanted the simple recognition of their rights and their dignity. They wanted a governance system which was people-centric as opposed to politician-centric. And they wanted a system which was also closer to them, which wasn't, someplace very far and inaccessible. And unfortunately, what we saw is the very politicians who sat and drafted the provisions of this constitution based on the submissions of the people, they went on campaigns against the very things which they have drafted, because they realized that actually if they introduce a system which the public actually wanted, that they will no longer be able to control and manipulate and dictate the futures and lives of the citizenry. And maybe that is why our politicians and our leaders don't like public and don't have these public consultations as much as they needed, because that would deny them the abilities to continuously exploit them. But I think it is the public's duty to continuously demand from government to have public consultations and to mandate such consultations before any legislation is passed in Parliament. And I think that would really bridge this gap in the public's inability to understand and comprehend legislation, which then affects their ability to access justice.
Definitely, and I strongly think that will be a very comprehensive solution to this mismatch between what the public think and what the government is doing. So along with that note, we we would wind up today's episode of Law and Order for today. And on behalf of Sri Lanka Rupavahini Corporation, we extend our thanks to Mr. Aditya Wickramasinghe for making time for to participate in this Law and Order program. And to all our viewers, we would meet you once again next week with another informative and interesting discussion on law and order. A very good night.